Hello, good evening everyone. AmerBON is back with the 10th Legal Aid Chit Chat session. Today we have four speakers. We have Edmund, Joshua, Sinyu and Michael. Amir will be joining us later, so stay tuned for him. Today, the topic about the Legal Aid Chit Chat session is money laundering and corporate greed. We will talk about the Anti-Money Laundering Act 2001, and our speakers will talk about what the laws are and what are the process that's within this law and how it usually was in the court. First, I would like to invite Joshua to give us a brief overview of the law and what you know about the investigating process, as I think a lot of people would be interested to know about it. Okay, Joshua, we can begin now. Thanks.
Hi everyone. Recently I think we have read in the news, right? I think over the past few years about AMLA being used in investigation, the AMLA laws being used in court. Basically, mostly revolving 1MDB lah. And I think most recently, if you guys can remember, in those cases involving Rizal Manso and I think some of the political parties or even companies or individuals which has allegedly received money from the 1MDB funds. So I think today what I am going to do is to give a brief overview of the AMLA or money laundering laws in Malaysia. So I will basically touch on three main issues, which is the offense, the investigation process, and the court process. So let me start by just introducing the law. Basically, in Malaysia, the money laundering laws is governed by this act. It's quite a mouthful. It's the Anti-Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activities Act 2001. So basically, all the money laundering laws are contained in those acts. It's quite a lengthy, quite a long act, and it deals with a lot other issues which I'm not going to touch about. For example, reporting obligations for certain businesses or institutions, the secrecy provisions, and maybe some of the evidential rules which is applicable for these AMLA cases in court. But I would like to start with the first topic, which is the offense. So there are a few offences created under the AMLA Act, and the most commonly used or invoked is Section 4. Basically, Section 4 is an offence for dealing with proceeds of unlawful activity. So that is, I think, the definition of, very simply, that's basically the definition of money laundering in the Act. So if we look at the Act, of course, I say dealing with proceeds of unlawful activity. That's a very generic description of the offences. But under the Act, you have a list of activities which may be considered as dealing with those proceeds. So under the Act, you have engaging directly or indirectly, acquiring, receiving, possessing, disguising, transferring, converting, removing from Malaysia, concealing, disguising, and many more. That's just, I think I only mentioned half of the acts which may be considered as dealing with proceeds of unlawful activity. So you may then ask, what are proceeds of unlawful activity? Again, very very simply, it means any property or economic advantage which you have obtained or derived from a criminal activity as prescribed under AMLA, as falling under serious offences. So this property or unlawful, say property or economic advantage can be in various forms. It can be in monies, shares, cars, and arguably maybe even cows or cattle or goats, and so on and so forth. So this is why, and this term proceeds of unlawful activity is the reason why um, we lawyers always mention this word predicate offense when it comes to AMLA related offenses, because basically to show that this certain property is derived from unlawful activity, it must be shown or it must be proven that those activities are criminal activities as falling within the schedule under the AMLA Act. So these are what we loosely call predicate offense, meaning you must prove the offense, the predicate offense, before then subsequently proving that this monies proceeds from those predicate offenses. So examples of um, predicate offences, generally they include most types of white collar crime under the penal code. For example, cheating, CBT, also includes corruption, and for other kinds of species of offences, maybe tax evasion, smuggling of contraband items, and dangerous drugs, firearms, and those kind of things. And even, of course, not forgetting terrorism activities. Actually, that is one of the main aim of AMLA being enacted. So that, I think, is in a nutshell is what Section 4 is all about, and it's actually quite a serious offence. It carries let me look at it, a term of imprisonment not exceeding 15 years and a fine not less than 5 times the sum or value of the proceeds of unlawful activity. So it's quite a serious offense. It carries a maximum of 15 years, and if you uh, are like are liable of committing, of money laundering a sum of 1 million, you can fine up to 5 times of that amount. So maximum fine of 5 million. So the punishment is actually quite harsh. I think it reflects the concern by the government to stamp down, I think at that point in time, corruption and terrorism activities. So that's the first offense. Of course, there are other offenses like falsification of document, which is not very commonly invoked under AMLA laws. There's also offences on breaching secrecy provisions under the AMLA legislation. And I think the another recent one which was added was Section 4A, which is structuring a transaction to evade reporting obligation. So very quickly, this section covers okay, so let me put it the other way. So for businesses, certain businesses and I think institutions, there's an obligation to report. There's a reporting obligation imposed under AMLA. So for us, like legal firms, there's certain AMLA guidelines which we have to comply. And for example, I think the most easiest example I can recall is that if a client passes you cash exceeding a certain amount, then you have to report that transaction to Bank Negara. So Section 4A covers this kind of situation where, for example, you a client comes to you and brings 1 million cash, and to avoid uh, reporting to Bank Negara about this receipt of funds, you basically advise the client to or you strategize with the client, or even if the client strategize with you to maybe stagger that payment so that you avoid reporting uh, to Bank Negara about the amount received. So arguably that will fall under Section 4A, which is also which carries uh, a punishment not as severe as Section 4, but it basically you can be imprisoned for a term not exceeding 7 years and fine not exceeding 5 times the value of the transaction. Okay, so that's the first part of the uh, topic which I was going to talk about. That's the offense part, and the second part, I think, which more people are, a lot of people are more interested in is the investigation part. So, when police when a complaint is lodged about the commission of an offense, the police will then, as a matter of course, investigate such offense. So, in the course of investigating that offense, um, the police has a power given under the AMLA Act to make a freezing order. So this freezing order is made under Section 44. It can be made by any enforcement agency. So just now I used the example police, but it's not limited to just the police. The MACC can use it, the customs can use it, LHDN can use it, and other enforcement agencies. So this freezing order made under Section 44 basically prohibits you from dealing with that property within a period of a maximum of 90 days. So, of course, the police, 90 days is a maximum period, but of course, the police has the discretion to reduce the period if they find that it's no longer necessary to have the property frozen. And I think there's another misconception or a little known fact about Section 44 is that under Section 44, the police can also prohibit someone from leaving Malaysia. So, in that Section 44, under Section 44, they must issue you an order. And in that order, it must be stated that you are prohibited from leaving Malaysia and you must surrender all your travel documents to the Director General of Immigration. So, I have seen the police using that particular provision in one case which I've done, and of course we have challenged it before for failing to non-compliance of procedure, and we actually won. So basically, this order under Section 44 must be served on the person or even to the company. Basically, they cannot do it in secret lah. They cannot just simply issue a freezing order without notifying the other party or the aggrieved party. Next is, I think, another important aspect of the investigation process is Section 44A, capital A, which allows the enforcement agency or to vary the freezing order. So, for example, if pursuant to an investigation, the police freezes all your monies in all your bank accounts, and you may have problems getting money to pay for your maybe house installment, car installment, or even your daily expenses to feed your family, your dog, and whatnot. So under Section 44, the law actually allows you um, to request from the enforcement authority or agency to allow certain portion of the frozen property to be released to make payments for such purpose which I've mentioned earlier. And I think for legal fees, they allow those frozen sums to be varied or to be released to pay legal fees, because if you get stuck in this problem, you may need to engage a lawyer and be legally represented. Um, Third is the section 50, which talks about a seizing order. So, like I mentioned earlier, section 44 has a period of 90 days. So, at the end of 90 days, if there's no other further action taken, then the police must release you the money. The freezing order automatically lapse. But if they think that it is necessary to conduct further investigation, usually what they will do is they will refer the matter to a DPP, and the DPP, after looking at the investigation papers, may issue what we call a seizing order. And this seizing order, of course, it can also cover both movable and immovable properties, um, and it has and the DPP can issue that order for a period of 12 months, so a year lah. And the period of 12 months. So then you may ask, when does this 12 months start? Does it start from the date of the order, the seizing order by the DPP, or does it start from the freezing order when the property is first frozen? So the answer is actually in the act. So the answer is that if there is a prior freezing order, the 12 months will start from the date of the freezing order. So, and if there is no prior freezing order, then it will start from the date of the seizing order. So basically, if the police has frozen your property for 90 days, and then subsequently they would try to get they want to obtain a seizing order, that seizing order can only be an additional of another 9 months. Yeah. So those are the powers, basically the powers which can be exercised by the authorities when investigating money laundering crime. The third is the third topic which I wanted to talk about is the court process. So, after investigating, after performing investigation, conducting investigation, and if the authorities find that, okay, these monies or these properties are proceeds of unlawful activity, then there are several options which the authorities can take. The first is, of course, to prosecute the person, the individual or a company under Section 4 or Section 4A, as I mentioned earlier in the first topic. Um, Secondly, is if there is no prosecution, so if they prosecute you, the prosecution can also then apply for the property in question to be forfeited at the end of the prosecution. So after the trial has proceeded and towards the end, the prosecution may then make an application and ask the judge to forfeit, ask the court to forfeit the so-called the subject matter of the crime, the property, the proceeds of unlawful activity. And the interesting part, I think, is that even if you are acquitted of the predicate offense, or even if you're acquitted of Section 4, it doesn't mean automatically that the court will not forfeit the property. So the court may still find that those properties are proceeds of unlawful activity and may then, proceed to forfeit um, the monies or proper, properties as they may be. The next course of action, if there is no prosecution, then the prosecution may apply for what we call a civil forfeiture, meaning there's no prosecution, but they make an application to court to forfeit the certain properties which they suspect uh, or amounts to proceeds of unlawful activity. So for this kind of civil forfeiture, there is no need to go for a trial. Basically, the prosecution just puts in an application and supported by affidavit justifying or outlining the reasons why they think these proceeds of unlawful activity and why this properties should be forfeited. So those under AMLA, those are the recourses which the authorities can rely on in dealing with money laundering offense. So I think I've spoken for about 20 minutes. I think that suffices lah for as a brief overview of money laundering laws in Malaysia. I think Ame and the rest will delve deeper into more detail. Thank you. If you have any questions, you can just ask in the comment section. We will try to address them. So don't ask hard questions. Thank you.
Maybe Joshua, since you raised the topic, and before I think we go on, the recent decision by Zaini in the UMNO case, and I think it's a simple answer, but he decided that so long as the money was spent, you cannot forfeit the money under AMLA. That means that a way of getting out of AMLA is to steal the money, immediately transfer it to somebody's bank account, and then immediately use the money in cash or otherwise. The prosecution would then not be able to find the money. Is this one way of getting out of it, or is Chinese decision accurate? Because in February 2020, he decided that he cannot forfeit the UMNO money because the money had already been spent.
Okay.
It's okay, Josh. I think let me address that question
Okay.
that Emma has posed. First, we have to understand that the AMLA should not be used as a debt collection procedure. That has to be clear. That was never the objective or the intention of the Parliament. So we cannot simply file for forfeiture application with the intention of recouping a recurring debt or money that purportedly or illegal proceeds that purportedly been utilized or transacted. That's not the objective. The objective is to get illegal proceeds, not to recover monies that you think that had been used by individuals who had committed predicate offences or committed unlawful activities. The reason why you have to understand that once the illegal proceed had been utilized and it cannot be forfeited is because you need to identify the object that is the subject matter of the unlawful proceed. One of the elements that has to be established if you want to prosecute someone under AMLA under Section 4, which Joshua had discussed, is that there has to be an unlawful activity. Okay, the unlawful activity can be a predefined offense or a predicate offense as set out in the list. And then the second element that has to be established by the prosecution that the unlawful proceed must be identifiable. So you need to be able to show that if you're talking about this amount of money, that particular money is the actual unlawful proceeds, not the value of the unlawful proceeds. So for example, in the case of UMNO, I mean, I have not read the judgment of Zaini. My understanding of his judgment is that if a certain amount of money, which is claimed to be unlawful proceed, had been transferred to UMNO's account, now UMNO had utilized that amount of money. You cannot subsequently file for future proceeding to freeze UMNO's account or UMNO's property, which have got nothing to do with the unlawful activity. You cannot use AMLA as a means to recover the value that you say is the value of the unlawful proceed. That has to be appreciated. That is not the objective of AMLA. But if the money can be shown in the account, for example, if on 1st of July, for example, 1st of July 2020, the unlawful proceed was transferred into A's account, and that amount of money remains in A account, if you can show that that is the unlawful proceed, then that particular transaction that been transferred into A's account on the 1st July 2020, then that particular proceed can be subjected to the forfeiture proceeding. But if you had utilized the money for whatever purpose, and subsequently say few months down the line, you instituted or you filed a forfeiture proceeding, but from 1st July until the date when the forfeiture proceeding had been filed by the authorities, you had received lawful proceeds. You have received lawful proceeds from lawful activities. You cannot then forfeit those lawful proceeds that you have received. So whether you like it or not, I mean, timing is also of the essence as to when you file the forfeiture proceeding. That is why the Act itself gives wide powers to the authorities to seize the account and subsequently to freeze the account. I mean, if you're talking about the total period whereby you can seize and freeze the account, it can come to 1 year. That would allow the illegal proceed to remain in the account in question, for example, or that the unlawful proceed to not be transacted until the investigation is completed or until they decided to charge or prosecute someone under Section 4 of the AMLA Act. So that, I think, answers your question, Edmund.
What if the money is mixed?
Well, as far as the decision of the Court of Appeal in Kuala Dimensi, one of the elements that you have to establish that the unlawful proceed must be identifiable. So whether it could be a painful process, but if you follow by the decision of the Court of Appeal in Kuala Dimensi that the unlawful proceed has to be identifiable, then you need to go to proper accounting process, audit process, and show that that particular property or that particular money is unlawful proceed.
What if you forfeit the account for being an instrumentality of the offense instead of being a proceed of unlawful activity? Yui, can you bring up section 56 of AMLA? If you have it with you.
Yes, just give me a second, I will screen it.
Yeah, because
so, are you saying that therefore it is wrong to freeze the account? Is that where you're heading? Is that what you're getting at?
No. I'm saying that if you look at the scheme of AMLA, you have the freezing orders and you have the forfeiture provisions. So the scheme of AMLA, it's meant for the authorities to react quickly so that they are able to freeze and sort of catch the proceeds or the account and prevent further transfer. So it's less effective when it's used after a long time after the event. But the problem is that when it comes to forfeiture of property, there's actually two types. The first, if it's being a proceed, and it's a subject matter or it's a terrorist property, and there's a second limb that property is an instrumentality of the offense. So, i.e. an instrument to put it simply. If a bank account is used as being part of an instrument of the property, then you're gonna have a problem there. Can you zoom into number subsection 2? Yeah, zoom subsection 2. You see, so there's two parts. The property that's the first three I mentioned earlier, and then number 4. So if the bank account, I suppose in Zaini's case, they went under 3. But had they gone under 4, would it be forfeited? I'm not sure if a bank account can be considered a property.
Instrument.
Yeah. Well, an instrument, I think it would. But whether it's a property of that person or it's a property belonging to a bank, we're not sure, because there's this view that a bank account is actually not the bank owners, the account owners, even though it's being called an account owner, but it's actually belonging to the bank rather than the person opening that account.
Okay, so if I can add on, if going based on what you said just now, that the account itself is the instrumentality of the offense, therefore you are freezing the account. You're saying that therefore the account ought to be forfeited. But the question is, what if the account contains lawful proceeds?
Yeah,
Because
so
an account, while may be utilized as a means to launder the money, and whereby you transfer from account A to account B to account C, but if in those accounts contain lawful proceeds, there will be an issue that whether or not you are entitled to forfeit those monies which were obtained from lawful means.
yeah, so it's distinct, isn't it? Because you have on one hand the money that's inside the account, so that is a property, because you can have property in money, and you have the account, which, you know, assuming that it is a property, then there would be two distinct properties here. So when the judge makes a forfeiture order of the property, he would be making an order on the bank account. So you forfeit the property being the bank account rather than you forfeiting the money inside the bank account, because number one, if it's lawful, then it clearly wouldn't fall under any of the four categories listed here. You know, it's not a proceed of an unlawful activity, or it's not an instrument use. But of course, you know, we haven't seen. I don't think we have any case where it breaks it down to such technical level. But I mean, I'm just throwing it out there, you know, because I think it's more technical than it is as presented by the Malaysian courts.
Yeah.
There's
Yes,
this
I
whole
mean,
argument
the
about
point
the
that you raised is very,
AMLA is unconstitutional. I
the
have my
question
views
that
on
you
that.
put is very technical. I agree. The question that you put just now is very technical, and most of the application for forfeiture focus mainly on the proceeds of an unlawful activity. So they're
Yeah,
focusing about the money rather than the account itself. I mean, in a way, you can say that the account is a separate property uh, from the unlawful proceeds itself. But most of the cases that we have come across, most of the forfeiture application that have been filed deals with proceeds of unlawful activity. I mean, that is the most common application that we come across.
yeah, yeah.
Yeah.
Thank you very much, Joshua, Amir, and Sinyu. Just wondering if there is any defenses for when you are accused of committing money laundering, because, like, for example, we have seen the case of Najib's money laundering case, which has gone on for so many years. So is there any defenses that have been commonly relied on? Perhaps Edmund or Amir has any words on this.
Yeah, I will address this issue here. Thanks. All offense will definitely have offense defenses that can be relied upon. Um, in order to look at what are the possible arguments or defenses that we could mount in order to challenge a case under Section 4 of the AMLA, we need to appreciate what are the elements that the prosecution has to establish. First, as we have discussed earlier on, that there has to be an unlawful activity, there has to be a predicate offense. So if you are able to show to the court that there is no predicate offense, that the offense that they claim to have be the starting point of the unlawful activity doesn't exist or could not be established. So that is definitely one of the possible arguments that can be put forward. And then in terms of the proceeds, you must be able to identify what is the unlawful proceed. I mean, if you're unable to identify the unlawful proceeds, then one of the elements under Section 4 could not be established. And of course, you need to show what is the act of laundering, what is the act that is associated with money laundering. It is distinct and separate from the unlawful activity itself. If you look at the Visa Aziz case, a lot of people say that, oh, theft, you steal X amount of money and then, oh, you only return. Look, Riza is not charged with committing a predicate offense. Riza Aziz is charged with money laundering activity. He is not charged with the predicate offense. So he has not been accused of committing any unlawful activity. He's only been charged with committing activities, i.e. handling the unlawful proceeds, which is different. So all this analogy given by Mahathir about stealing chicken, everything, that is totally wrong. Majority of the public fail to appreciate, understand there is a distinct action, distinct actors reus. Unlawful activity is an action by itself. Dealing with the proceeds from the unlawful activity is a separate action on its own. So you need to show that there has to be a nexus between what the person who's been charged with engaging in money laundering activity with the unlawful activity itself, or with the proceeds itself, sorry. So if you cannot show the nexus, you cannot establish the nexus, then that is also another argument that can be put forward. And last but not least, the most important element that has to be established by the prosecution will be the element of mens rea, knowledge. The person must have knowledge that he is actually dealing with unlawful proceeds. And if it can be established, if it can be shown through the factual metrics that he has no knowledge, or he has been duped, he has been cheated, he has been misrepresented, that he is actually handling legal proceed, then that person may argue that, look, I mean, I have not committed an offense because I lack the necessary knowledge, the mens rea of committing the offense. So these are the issues or defenses, argument that can be raised in order to challenge that. And apart from that, Joshua did mention about there's a requirement for certain professional bodies or requirement by certain institutions to do certain checks in terms of dealing with monies received from clients, for example. Now, if you could show, if someone charged with Section 4, if the person could show that he has taken reasonable steps, has done all that is necessary and reasonable in order to make sure that the property or the money that he or she receives do not come from dubious activity. Therefore, that argument could be raised to show that the person doesn't have the necessary mens rea, and the conduct that he or she had undertaken shows that he or she had acted reasonably, therefore would not want to participate in such unlawful activity. So broadly, generally, those are the issues that could be raised as defenses in order to defeat a charge under AMLA. If you want further advice or further opinion as to what are the possible defenses, by all means, you can always engage us. We'll be more happy to look into your case.
Yeah, Ame is already wearing a white collar, you know, despite.
Yeah, we're all wearing white collar because we are doing white collar crime.
I think there's another aspect which is the bona fide parties, the claim by bona fide parties. So I think
order forfeiture, yeah.
I think Ame can just expand a bit on that, and whether I think you can use
didn't
it
you
as
try to claim
form of
I
defense.
I thought you tried to claim for your legal fees under that.
I know there are lawyers in the past who had filed application under this third party bona fide claim to claim for their legal fees. The legal fees is an interesting issue. Normally, Joshua, you mentioned just now that there is an exception whereby the monies in the account which has been frozen could be buried, whereby part of it could be utilized for your daily expenses to meet your daily needs, and of course part of it could be used for your legal fees. But more often than not, that seems to deal with the situation when the person is still under investigation, and of course most probably during the course of the trial that may happen upon the completion of the trial. But what if let's look at this hypothetical scenario. What if once the trial had concluded and then he's been convicted, and that particular person decides to engage a different set of legal team? Can the new legal team make an application, or can the accused person then make an application to vary the order so that he who could use part of those frozen money to pay the new legal team that is representing him at the appeal stage. The Act doesn't seem to suggest that. It is still a gray area there, but from some cases that I've come across, there seems to be a decision, or at least an agreement, that even counsel who came in at the later stage, at the appellate stage, is entitled to get legal fees from those frozen monies.
Yeah, I think that only makes sense, you know. Otherwise, how it's going to affect your right to counsel and right to a fair trial if you are locked out of your own money. And you know, we must not forget that there's this presumption of innocence that, you know, seems largely ignored nowadays by
Yeah,
the
but
courts and
unfortunately,
by the
you
authorities.
will come across objection from the prosecution or from the authorities when such application is made, because they said, oh, this application could only be made at the earlier stage, or anyway, he's already like engaged a different set of lawyers during the trial and paid fees, and therefore he is not entitled to make any further request for variation of the freezing order. Well, you'll be
No lah,
surprised.
right to counsel includes right to change counsel.
I agree with
Not
you.
stuck
I
in
agree with
one
you.
set of
Unfortunately,
lawyers.
unfortunately, there are prosecutors and authorities that think otherwise. But if you look it in the context that presumption of innocence applies throughout the court procedure, which is from the trial stage up to the appellate stage, then of course the person is entitled to get his legal fees or take legal fees from the frozen account and pay his counsel or his legal team.
There is a decision by JC Ahmad Shahir actually that goes against what you are saying, because he says basically you, even if you raise knowledge that you innocently did not know the money came from an illicit source, that money is still liable to be forfeited, because all the prosecution needs to prove is that the money came from a source as unlawful activity, and there was no good faith purchaser for value. So the case of Parti Bersatu Rakyat Sabah, I think the defense in May 2020 was that the money coming from Najib's account of 1 million was used to pay back the party when the party used the money for services in the constituency. And then the JC said, it doesn't matter why you used it, so long as the prosecution proves that the money came from an illicit source for an unlawful activity. And he goes through in the judgment in quite detail, repeating the IO's affidavit, why the money was from an unlawful activity. And it's very interesting because what it does is that it really just circumvents the decision in Najib's trial, because that judgment in May already goes into findings of fact, that he accepts what the IO says, that the money is actually unlawful. So this defense of knowledge may not be available if it's not in statute, because in statute it only talks about good faith. That's my question, because that is relevant to Najib's case as well.
Okay,
Yeah, but
I
you see,
personally. Okay, now go ahead first.
go on, go on.
No,
No.
I personally have my. Oh, sorry.
No, you go.
Okay, I have my personal views on that particular decision. I disagree with the view that was taken by the judge in that particular case. I maintain my view that when it comes to forfeiture, you can only forfeit something which is still in existence. You cannot forfeit something which is no longer in existence. Granted, the fact that you have received an illegal proceed, unlawful proceeds from illegal activity, the fact that you have received it, that is an offense by itself. But if you have spent that particular proceed, for example, or even if you have destroyed that property, what is it that you are forfeiting? For example, I give you a gold bar. That gold bar was obtained from an act of robbery, which is an unlawful activity, which is a predicate offense under the penal code. You committed the predicate offense. You then pass that gold bar to me. Now I handed that gold bar, so I'm in possession of this unlawful proceed, which is an offence which can be prosecuted under Section 4 of AMLA Act. Now, what if I then, not knowing to you, decided to destroy that gold bar that I received for whatever reason or for whatever purposes? What is it that you could forfeit? Because the subject matter is no longer in existence. That is why I said the objective of the AMLA Act is not to recover the value of the unlawful proceed, but rather to recover the actual unlawful proceeds. But because we're looking at money, and normally we look in terms of the value of the money that one has received. And that's why I think Justice Shahir in that case decided, oh, you still can forfeit the monies in the account as long as there's money. Whereas those monies could very well be from lawful source. Because we are looking at the value rather than the object itself. So that is my view. And I tend to disagree. In terms of knowledge, whether someone has committed an offense, of course, there are certain inferences that could be made under the Act. It's very clear under Section 4, Subsection 2, it says that inferences could be made that that person has knowledge or reason to believe that these are unlawful proceeds. But inferences, like all other legal inferences, they can always be rebutted. It is not something which is unrebuttable. So if you could clearly show, but of course, this all depends on the factual metrics. Depends on the circumstances of the case. Depends on to what extent whether your denial of knowledge or your lack of knowledge of those unlawful activity or receiving the unlawful proceed is reasonable or not. That depends on the facts. But to outrightly dismiss that as a defense, I think that is wrong in law.
So in essence, for a layperson, if I want to get around a money laundering offense, number one, what I do is I collect the money, take it as...
No, Ahmad, sorry. Your question is premised on the wrong footing. You're saying that get around on money laundering offense. I was discussing about forfeiture. Forfeiture and the offense are two different things.
So forfeiture based on money laundering, somebody can get around it by getting money, not knowing or knowing it is from illicit sources, and then not spending it on himself or herself, but spending it on somebody else by way of purchasing something in cash.
No, that's different. If that thing is still could be traced, that is still part of the unlawful proceed. It just changed in terms of form, but it's still identifiable. But if you're talking about value,
it needs to be a purchase. You cannot give away.
Yeah. If you're talking about money in the account which has been spent, how is it that you're going to forfeit that particular money that has been spent? So we have to be clear. We cannot simply just say, oh, once you receive it, doesn't matter what is the value, I can make an order for the same value to be forfeited. That is wrong. That is a simplistic approach, because we have to look at the facts of the case. Now, every unlawful proceed has very wide definition, but we are more accustomed to monetary transaction, online transaction. But in reality, we deal with so many other objects. Like I said, I use a gold bar example because that can clearly drive the point that I'm making. Or for example, a car. The car that is being used in the commission of an unlawful activity is something which can be forfeited.
Yeah, that's a problem with Justice Shahir's decision, because and to be honest, other cases as well, because you start to conflate the bank account with the money inside the bank account, which are different things. So that from that premise alone, if you conflate the two, then for me that's wrong in law already. That's not something that is provided under Section 56. But I don't see that argument being raised before Shahir, I think. Justice Shahir, I think.
I think on the example Amir gave, right, on the gold bar, right, my question is, can the prosecution then apply Section 59 for the court to make pecuniary orders to assess the value of the gold bar and then order that person implicated to pay that
That's
value.
different. That's different. That is not forfeiture. Because what Emma posed just now,
Correct.
Emma was referring to Shahid's case about
Correct.
the money that went into Amla's account. That's why Zaini's decision is far more correct. As far as I'm concerned, I would agree with Justice Zaini's decision.
Yeah, so I think that decision, right, which Edmund mentioned by Justice Shahi, I think that one I didn't read I haven't read properly the judgment, but I think it can be distinguished because we were talking about the element of knowledge for the prosecution of an offence under Section 4. Because Section 4 actually talks about knowledge. I think under subsection 2 or subsection 3, it says that you may infer knowledge or the lack of it from the background circumstances or extenuating circumstances. So then it implies that there is this element of knowledge under Section 4. For the forfeiture, I think I explained it earlier that that's why even if you have been acquitted of the offence under Section 4, it doesn't mean the property cannot be forfeited, because it may be still be considered proceeds of unlawful activity. So I think that you can distinguish Justice Shahi's decision on that point.
Just to add on to what Joshua said, the last part, what is important is not a conviction for the predicate offence. What is as important is that the offence is established. So a person may still be acquitted, but if you can show that the offence actually took place, that there was an illegal activity and there's unlawful proceed, then you are able to establish a case under Section 4. You can also then proceed under the forfeiture proceeding, even though there was no conviction of the predicate offence. Because conviction deals with the person who committed the offence, not the existence of the offence. It's a bit technical, but if you look carefully, I think that's why Abang Iskandar in the case of, I think Azmi something, can't remember. He said it's immaterial that someone is convicted or acquitted of the predicate offence. But what is important ultimately is the offence of the unlawful activity itself, whether that could be established as the prerequisite for a case under Section 4, as well as subsequently forfeiture proceeding.
But I mean, even that view, right, it's problematic, because when somebody has been acquitted and, he can still have his properties forfeited, for me, that's problematic because, well, there's basically two views to this, but I'll tell you my view first. My view is that when you forfeit someone's property, it's akin to a criminal proceeding, to a criminal penalty. So for you to have undergone trial and been acquitted, and then yet have your properties forfeited in a separate proceedings, that to me it's double jeopardy. Or it can amount to double jeopardy, even though the classification of the subject matter is different, but effectively what is being put on trial is what you had done. So for me, that's double jeopardy, and it's unconstitutional.
I totally agree with you.
Of course we will agree.
The problem is because the problem because with regard to the separate forfeiture proceeding in the act, they have set a different standard of proof.
Correct.
That is the problem, which is subject to argument and challenge.
Actually, we have come across an example, right? In our case, one of the cases we have done where the prosecution decided to charge for the predicate offence, but not to charge for an offence under Section 4. Yeah. Then at the same time, they took up civil forfeiture proceedings in respect of the subject matter of that offence, that predicate offence. So I think what we argued, we did argue in court on that point, and I think we argued double jeopardy, and we argued for a stay of proceedings and all that. Because I think even if you go under the normal CPC, even if they can, if they have proven or the offence against that person, they can still forfeit under the CPC. They do not have to rely on AMLA. Yeah. And filing a civil forfeiture amounts to a collateral proceeding. Basically, the prosecution is taking two bites of the same pie.
Abuse of
But you see,
process lah.
the problem there is that when it comes to criminal offense, right, there are criminal offense where the penalty is only a fine, you know. So how is that any different from forfeiture proceedings where the penalty you get is on your property? Of course, the second view, which I didn't mention earlier, is that when it comes to criminal proceedings, it's a proceedings in personam against that person. When it comes to forfeiture, it's proceedings in rem against the property. But for me, that is, you know, you're splitting hairs lah, because you are really missing the core matter here, which is whether or not that person had actually committed a crime. In fact, if you ask me, forfeiture proceedings under AMLA is more oppressive than criminal proceedings because the standard is much lower, so you don't have all the safeguards that is necessary, you know, that would be there in a criminal trial. So it's very problematic, AMLA, and I think even the US Supreme Court, can't remember which judge, he did raise concerns about forfeiture proceedings under money laundering laws. So I think we should challenge it lah.
Yeah, I agree. I mean, the act itself is very, very confers wide powers. Well, some even said draconian powers to the investigative authorities, and sometimes it can be abused, whereby you freeze party person's account, hoping that a person will keep in and obtain something from that person. Well, the possibilities are endless. So, and with insufficient safeguards, I think it can be abused in the wrong hands.
This is a creation by United States of America. After 9/11, all these laws came up. You know, they went under that guise of counter-terrorism. So, you know, it's the same thing. Every time there's a global crisis, you know, oppressive countries use it as an excuse to pass oppressive laws. So when AMLA was passed, you know, everyone's like, oh, counter-terrorism, we need all these laws to protect ourselves. And now you see it's not being used for counter-terrorism purposes.
Yeah.
So we got to be very careful lah.
Yeah, I think our AMLA was enacted pursuant to that treaty, right, which we ratified, and then we enacted AMLA. But I think Singapore, if I'm not mistaken, they have a different system for, you know, one for money laundering for normal cases, commercial cases, and then there's another one, a more draconian one for terrorism one. So it's, you know, to justify.
Well, you know why people go to Singapore for, what? So they need to be friendly.
That could be considered as false information, and you
better not go Singapore anytime soon.
So yes, Jay. Anything else?
I think we've used up the 1 hour time slot without even addressing any questions.
Yeah, we don't even give Mike a chance to say anything.
Yeah, so it's already
But
1 hour.
I think Edmund is surprisingly quiet, right? In this session.
No, he purposely, because this is the last episode for first season of our Legal Aid Chit Chat. So he's gonna leave it on the cliffhanger, so that when we start the first episode of season 2, he's gonna start with the bang.
Let's not do another season lah.
Well, it depends on the response for the public. If there's a demand for it, why not?
But the response based on the live comment section seems to be very overwhelming lah.
Are you sure? I haven't checked it. Okay, I think we've been chatting among ourselves for quite some time. So yeah, any other further question, Yue?
Just wondering, like, if there's like illegal proceeds, and then I wonder
No, I'm just kidding. That's a rhetoric question. You're not supposed to ask any question. Just kidding.
I don't know. I can give you so.
The topic says corporate greed. What? Why did we not talk about corporate greed? We need to talk about
that's where Edmund comes in. What? That's where Edmund's supposed to come in. Yeah,
Where's
corporate greed. I'm a socialist
Issue is
lawyer.
bleeding.
Thanks, UA, for organizing all this.
No, that's all.
Hey,
After that, anything else to address?
Yeah, corporate greed is something that
money laundering to human rights issue. Maybe something like how we can link money laundering to human rights issue. Is there something like this?
corruption and money laundering are issues that affect the economic, social, cultural rights of people. But people don't link it
Let's not
enough.
forget, Edmund, don't forget,
the money.
Yeah.
the new section 17A of the MACC,
yeah.
that has repercussion. I mean, that has some correlation with AMLA. I mean, like, a lot of companies may not be aware of that, but an offence under section 17A could very well trigger the operation of AMLA. So an offence, and your officer may be doing some hanky-panky, and if the company is being charged under section 17A, the company's property or assets or even accounts could very well be subject to investigation under AMLA. So yes, companies should be very mindful and should be very cautious of what your employees or your office are doing.
Yeah, in fact, under the trust principles, right, for adequate measures which you need to put in place, I think one of the principles cover the monitoring of financial transactions to ensure those are not basically scam or dubious. It doesn't come from dubious sources lah. As part of an adequate measure. And then of course I think the KYC process also.
Well, the public wouldn't know what's KYC.
Basically it's very different from KY lah. Okay, so I think there's no questions, right, from the public. I think we have opened that comment section up for questions. Well, that is the opportunity to ask free questions and to get free legal advice.
Yeah, feel free to ask further question. You can always ask further questions after this episode, but it will come with a fee.
Yeah, if anyone has any questions, you can always check out AmerBON.com, and then there's the contact us column where you can fill in your questions and we will answer, but with a fee. Yeah, so that concludes our session today. Thank you all the speakers and also Sue, Shara, who are not here today. Thank you so much for attending all these 10 sessions. It has been 3 months that we have been going on with this, and it has been very fruitful, and we have helped people to answer questions. If you have any questions, drop by AmerBON.com, but with a fee.
I think for
Okay,
those
see
who
you
have
next
followed
MCO.
those who have followed the series from episode 1 to episode 10, right, who have watched the entire session, right, I think there is a special prize by Edmund. Edmund will give a special gift.
Only PSM.
Unlawful proceed, is it? Unlawful proceed.
Yeah, identify yourself as the lawyer viewer and we will give a discount.
Yeah, and submit your proof that you have watched all 10 episodes to AmerBON.
Yeah, use the discount code AmerBON. If you don't use that, means you didn't watch our series today.
Maybe you get a free t-shirt or a notebook or something like that lah.
Yeah, thank
or
you so much.
you get like a 50 ringgit voucher for off legal fees, right?
Maybe you get a ring from Amir.
That one could be a proof of illegal activities lah. That one.
I ring can only give one person.
Get a ring and then have a photograph.
Okay. That's the end of today's session and the end of this season. Okay, thank you, Yue. Thank you, everyone.
Thank you,
Okay, bye.
everyone.
Bye.
Okay, bye.
Check out our Facebook page for season 2 soon. Bye.
There may or may not be a season 2. Bye.